start recording. There we go. So thank you for joining us this morning on the webinar, which is run by the Growth Hub in partnership with Stephens Scown. And this is the second of a series of two webinars that Laura and Chris have been delivering for us on the Employment Rights Act. This one particularly is looking a bit more of a forward look. The one previously, I'll talk about in just a second, that you can actually go back and watch if you would like to. So if we just get a little bit of housekeeping before we start. My name is Kirsty Musgrave and I'm the Operations Manager here at the Growth Hub. We're using the Zoho meeting platform this morning, which might be new to a few of you. So just to sort of orientate yourselves. You'll see that you've got a menu bar at the bottom. If you'd like to ask a question as we go through the webinar, please feel free to do that. And you can do that by clicking on the question mark. You'll see above the box where it says ask a question here, you have the option to ask it anonymously. If you choose that option, we won't see your name and none of the rest of the people on the webinar will see your name. However, if you want to share your name, that's absolutely fine. And then obviously we can always ask follow-up, we can answer follow-up questions if necessary. So entirely up to you if you would like to ask anonymously or share your name with us. Pick those up as they go through. If your question is answered during the webinar, that's absolutely fine. But rather than trying to remember what your question is, feel free to pop them in the Q&A box and we'll pick those up at the end. And then finally, just to reassure you, we are recording this webinar now. And so you will receive a copy of it. So even people who weren't able to join us live will receive a copy. And you can also share that with colleagues and people in other businesses if you think it's relevant. So just a little bit ahead of time to sort of say what the Growth Hub is. Hopefully most of you will have been aware of us. We've been around for 10 years now. We're actually a national government initiative. And locally we are funded by the National Shared Prosperity Fund, which in calling the answer silly is branded the Good Growth Programme or the Good Growth Fund. So you may have come across both of those. And essentially what we do is we're a signposting organisation. So we work with businesses of all kinds, people who've woken up that morning and decided to start a business, all the way through to large organisations who've been running 20 years, 25 years, and have got multi-million pounds worth of turnover. So whatever ambitions that business has, from small to large, we can work with them to understand what their challenges and opportunities are, and then we go away and do the research to see if we can find support, training, finance options to help you achieve your business goals. And you see, we can work with local businesses, but we also work with self-employed people, not-for-profits like community interest companies, social enterprises, and charities as well. So we are really open to everybody. And the offer is essentially a business review, which is a conversation with someone like Jane, one of our growth connectors there, you can see. We do that online via Microsoft Teams, and it's a conversation with you to understand what direction of travel you want to take your business, whether that's early stage all the way through to well-established. And then, as I said, we go away and do the legwork. We take the hassle out of you visiting 25 different websites and calling 5 different organisations to find out maybe if they can help you. So, as I said, this is the second of a series of 2 webinars, and the first one was around sort of the essentials. There is a watch back link there, and once I've handed over to Chris and Laura, I will post that in the chat, so you can actually click on that and go to that, and watch that back if you would like. And then just a little bit of a heads up in terms of what else you can do. So we have, in the next couple of days, we have a top tips webinar on business success. That's we are sponsoring the Rewind Radio Business Awards, Cornwall Business Awards. And so we are in collaboration with them, and my colleague Keris will be delivering a top tips webinar. So how to, if you've maybe submitted an application before and you haven't been that successful, or maybe it's the first time that you were thinking about applying for an award. That's how all the sort of the essentials that you need to know to how to submit a successful bid. Obviously, we can't guarantee, but it puts you on the right road. And then also we have a bid writing for purpose-led businesses. So we might have community interest companies, charities, social enterprises, or it might be actually that you are particularly purpose-led, but are a commercial profit-making business, and you are maybe looking to submit a bid, a grant for something. then that's a very popular webinar, and that's actually in the evening. But again, any of the webinars that we deliver, you can sign up, and if you aren't able to join us live, we'll send you a recording. And then in that vein, there's a number of webinars that we've already run there that might be of interest to you, and is accessible again on our YouTube channel, and I will share that link in the chat. And that is some interesting information about strategic branding, some financial models that might be interested again for those purposeful-led businesses. We've got one today. After I'm literally finished this, and I'll jump on the next one. So you'll be able to look at the video for that around recruiting volunteers, and also we colleagues of ours who run an EO Curious. So if you're interested in being an employee-owned company or an employee-owned trust, and I know Stephens Scown is also an employee-owned trust, and has worked with lots and lots of businesses to help them to transition into that kind of model. So all of those are available for you to have a look at or sign up to. And then if you want to keep up to date with what's going on locally, nationally, new support, new funding, new opportunities, and events and webinars like this or other conferences, feel free to sign up to our newsletter there. And that's the QR code that you can do, or you can just jump on our website, and the subscription button is right at the top there on every single page. So that's just, rather than you having to check back on a regular basis, it falls into your inbox. You can grab a cup of tea and keep up to date with what's going on. Also be aware, if you sign up and you register on our website, you can share your own news, which we will then push out via our social media channels. And also you can share your events that are coming up as well, that will appear on our events calendar. So that's enough from me. I'm going to hand over now to Chris and Laura in their very, very capable hands to talk a little bit more about the employment rights.
Thank you very much, Kirsty. I'll be starting. And Kirsty, just to confirm, I think you're changing our slides as well.
I am, yes. So we're doing our best Chris Whitty impression for those of you hashtag remember COVID to move the slides on. I'm ready and waiting.
Thank you very much. Thank you. So good morning, everybody, and welcome to our second session on the Employment Rights Act. And this is going to be on how to future-proof your business, with a particular focus on the October 2026 and 2027 reforms. So as Kirsty said, looking forward a bit more in this session. So next slide, please. Just wanted to give you a brief introduction to the firm that Chris and I work for. I know some of you will have attended our first session, so just a really brief recap to introduce ourselves. So we're Stephens Scown LLP. We began as a traditional law firm in Cornwall, and since then we've grown into one of the Southwest's leading law firms. And today we're proud to be both employee-owned and B Corp certified as well. And being employee owned is very central to who we are. It reflects our people first approach, where we support each other, tackle challenges together, and always strive to go over and above for our clients. We're also really pleased to be a multi-award winning law firm, and our employment team has recently been nominated for Employment Team of the Year. That's an award that's upcoming at the LexisNexis Legal Awards in 2026. So we're thrilled about that. Next slide, please. So today we're going to be speaking to you. My name's Laura McFadyen, and I'm joined by my experienced employment lawyer colleague, Chris Morse, as well. And we're both employment lawyers in our employment team, and we know a lot about the Employment Rights Act, which is what we're going to be speaking to you about today. And just to give you an overview of the session and what you can expect to experience in the way it's structured and what you can take away from it, we're going to be focusing on upcoming employment law reforms, so what that actually means in practice for you, and particularly with a focus on SMEs, how you can prepare in a realistic, proportionate and manageable way. So our aim is to not just tell you about the black letter of the proposed law, but really to focus on what you need to do rather than simply describing the legal changes. So I'm going to start briefly with a recap of the April 2026 reforms, which we spoke about in more detail in our first session. And then Chris is going to follow up with a bit more detail on the October 2026 changes. And I'll be speaking to you about 2027, so what to expect there. And then Chris is going to be telling you a bit more about the practical implications and what that means for your workforce going forward, and practical steps that you can take to deal with these changes. As Kirsty mentioned, we really want this session to be useful and interactive for you. So please put your questions in the chat. And during the session, we're going to be running some polls as well. They're anonymous, but we're going to talk about the results with Chris and I will be discussing them, and then we'll be able to take a view on what's happening for you on the ground. And of course, do reach out to us afterwards if you would like any help from us or our employment team on navigating the way forward. Next slide. So just a brief intro to the Employment Rights Act 2025. It's one of the most significant reforms to UK employment law in decades. There's a phased implementation that's progressing at the moment. Next month, in April 2026, that's going to be, I would say, the first major tranche of changes for most organisations. And really, the clock is ticking for employers of all sizes to start taking action and planning ahead for what's around the corner. And we think that for SMEs in particular, it represents a moment of real change. Smaller employers often feel the impact of new rights more quickly because they've got to manage it. They've got to make sure that they're organised. They might have less in the way of HR resources, potentially tighter budgets and more informal processes. So if there's a lot of changes that are taking place at the same time, it can prove a bit of a challenge. But it's also, as we see it, an opportunity as well. So as well as having to comply, it's a genuine opportunity by adapting early. You can make sure that you're embedding fair practices, improve staff engagement potentially, and make sure that you've got a more stable and resilient workforce. So these days, there's competitive labour markets, and that can become a real differentiator for you. So now we hope that you're a bit aware of the Employment Rights Act. You've joined this session, and we're going to help you take action going forwards. Next slide, please. So the key purpose of this slide is to highlight that the government has very usefully set out a roadmap of its changes, and it's refreshed that fairly recently in February. If you hover over the image there, then you should be able to get access to a summary of the changes, when they are, and the dates when they're due to take place as well. So I really recommend that you use that code and make sure that you can access that document. And it's basically a very clean, clear list of the changes when they're going to take effect. And it really does mean that you're going to be aware of what's happening when. It's just, you know, it's really useful, and it's very short as well. So if you don't do anything else after today, I would highly recommend that you have a look at that as a starting point. Next slide, please. So just a reminder about why we think early action matters, bearing in mind that changes are going to be taking effect from early April. So they're just around the corner for the first major tranche. If you take steps now, that's going to leave you time to budget for the changes ahead. So the first ones to take into account will include increased statutory sick pay, which I'll be talking about in a moment. There will be obligations, which mean that you will want to have stronger recruitment and probationary processes. You will almost certainly need to update your internal systems, your payroll, and if you know what's going to happen in the short, medium and longer term, you'll be in a really good position to make those changes. And it avoids pressure and making mistakes, and it means that you can make those changes in a proportionate, planned way. Next slide. Sorry, I think I've skipped past the, no, it's the readiness poll. So there should be a poll that people can take part in. And this is our poll just to see if you're feeling that you're going to be ready for the changes ahead, or if you're feeling that actually there's a lot still for you to prepare at the moment. So preparatory steps that you might be able to take could include being prepared for statutory sick pay starting from day one, making sure that your payroll's ready, knowing that paternity leave and unpaid parental leave are going to be starting from day one too, from April, and thinking ahead to other changes, things like greater protections against sexual harassment, updating your policies, training staff, being mindful that 0 hours working is going to become far more limited, and unfair dismissal rights are going to start a lot earlier. So just wondering how everybody's feeling about all of that.
Just from a navigation point of view there, Laura, if people, we've got 3 out of 9. So if people want to, on the left-hand side of your screen, there'll be a chat, a Q&A, and then a polls tab. So if you want to navigate to the polls tab, you can actually vote, just in case anyone.
Thank you.
Obviously, people might not want to, but if in case they weren't sure where the poll was, that's where it is.
Yes, thank you. Yeah, it's not obligatory, but we're just interested to see how everybody's feeling at the moment.
And hopefully you'll be able to see those, yeah. But it's somewhat unprepared is 60%, 66%, and then partially prepared is so it's sort of like a 2/3, third split at the moment.
Yes. Well, I would say that that's positive in that people are clearly taking action and they're thinking about it at the moment. It's certainly better than not being prepared at all. And the fact that you're here at this presentation and finding out more about it is obviously a really positive step as well. Chris, I don't know if you want to add anything.
It's not dissimilar to what we saw last time, and I think it's pretty reflective of the marketplace. To be honest, I'd be amazed if anyone was going to be ticking fully prepared at this stage. I mean, we as lawyers aren't fully prepared because we're still waiting on a lot of the regulation and consultations are still underway, etc.
Yes.
So no, I think it looks positive.
Yes, I totally agree. And you're right. It would be impossible to be 100% ready at the moment because there's a lot that's still unknown and we're waiting for the detail. So thank you. That was interesting to see. If we can move on to the next slide, please. So I'm just going to briefly remind you of the changes that are going to be taking effect from next month, so early April this year. As I've been saying, April 2026 marks the first major milestone in the rollout of the Employment Rights Act. For most employers, it's going to bring in a series of reforms that strengthen day one rights and increase protections for employees as well. So the changes that are going to be taking effect next month include day one rights to paternity and parental leave that are being introduced. Statutory sick pay rules are being reformed so that more workers are going to qualify. The lower earnings threshold is no longer going to apply, and there won't be any waiting days to qualify for statutory sick pay. It will apply from the first day of absence. There's going to be greater protective awards for failure to properly inform and consult in collective redundancy consultations. They're going to double potentially. And this phase of change also introduces the creation of the Fair Work Agency, and that's a new enforcement body which is designed to support and uphold employment rights. And it will include, at some point, potentially being able to bring claims on behalf of employees. It's going to be governing things like holiday pay entitlement, working time regulations, infringements. So it's basically going to be far-reaching, and they're going to have rights to come in and inspect employers' premises and look at documents. So it's just, I think, a heads up that there's going to be closer scrutiny on employers in that regard. And there's also going to be significant changes on how concerns about workplace behaviour will be handled. So where employees make disclosures relating to sexual harassment, these will soon potentially qualify as statutory protected whistleblowing complaints. So that means that employees who make complaints about sexual harassment may well have greater legal protections, and employers will have to handle those complaints even more mindfully and carefully than they do at the moment. Next slide, please. So this is just a quick heads up one. This change applies to larger employers who have 250 plus employees. They're being encouraged by the government from April 2026 to put in place voluntary equality action plans, which will include addressing the gender pay gap and also the menopause to support their employees. Those are going to become compulsory for larger employers by 2027. There's nothing to stop smaller employers taking action and introducing things like menopause policies and being proactive about this. And I think it's going to become an expectation of employees that employers in general are going to be more sensitive and aware of those types of issues. And the government has said that it's going to be issuing more detailed guidance on how to support employees during the menopause in the workplace, and that guidance will apply to all employers. So it's something to look out for. I'm now going to hand you over to Chris, who's going to tell you about the October 2026 changes.
Thank you, Laura. Before we dig into that, we've got our first question. So it might be an opportune moment to discuss that. The question is, how can we deal with persistent short-term sickness? I imagine that's sort of thinking in the context of SSP coming in from day one, and also the reduction in the unfair dismissal qualifying period. Any thoughts on that?
I would say that employers are going to need to be more proactive about persistent short-term sickness absence, and it may be cynical, but it may be more likely that employees are going to potentially do that, because if you're an employer and you've been, as is very common for SMEs, providing statutory sick pay and nothing more than that, then it may be off-putting to individuals to take 1 or 2 days off when they're not actually going to get paid anything. So I think that most employers would be supportive of paying employees if they're genuinely unwell, but it's the ones that are kind of swinging the lead where it might become more difficult. I think employers have really just got to keep an eye on those situations and not let them run on, and make sure that they're handling them and making sure that everything's documented, that they're having return to work chats with individuals and keeping an eye on the reasons why there's persistent sickness absences and where it's appropriate, and there might be some genuine underlying reason, making sure that employees are having occupational health reports where that's helpful to manage them. But there can be a fine line to maybe managing something as a capability health issue and a disciplinary issue. So I think it's just being sensitive about it all and being proactive and fair and equitable across the piece as an employer. So not something to ignore and something to be proactive about, I would say.
Thank you, Laura. I agree entirely. I think, as with so many things, when the ERA 2025 is fully in force, it's going to be so important to be thinking about your records and having good record keeping. I know from my experience of advising employers, it can be really helpful to dig into the data around sickness absence, especially short-term persistent sickness absence, because there can be patterns. Maybe it's coming up either before or after a holiday, or it's landing, mainly on a Monday or a Friday because someone's wanting a longer weekend. Again, cynical, but it does happen. So yeah, just important to be on top of that with your record keeping as well, and making sure your line managers know how to manage these things in accordance with your policies. So as Laura mentioned, I'm going to be sort of talking about the changes that are coming in October of this year. It's the sort of second major wave of changes after April, and there's many changes, so we've just tried to pick out the key ones. The first thing is the stronger duty to prevent sexual harassment. So since October 2024, we've had legislation that's introduced a mandatory legal duty for employers to proactively take reasonable steps to prevent harassment, sexual harassment in the workplace. So it's shifted from a more reactive to a proactive process. Now, From October 2026, there's going to be a further step up, as what the law is then going to require is that employers can show they took all reasonable steps, not just reasonable steps, to prevent sexual harassment of their employees during the course of their employment. Now, it's only an addition of one word, but it does represent a significant change for employers. Where the current duty is breached, tribunals can uplift discrimination compensation by up to 25%, and the Equality and Human Rights Commission has the power to investigate and take enforcement action. So it's quite a serious thing to get wrong. We're still awaiting government regulation to set out what steps will be considered reasonable for the purposes of an employer meeting their obligation to take all reasonable steps. But according to the latest fact sheet from the Department for Business and Trade, these regulations are not expected until 2027-2028, following a consultation period. So we're actually going to find ourselves in a situation where the duty to take all reasonable steps exists before the guidance on it is available, which is very much cart before horse, unfortunately. We do, however, have some non-statutory guidance that's available from the Equality and Human Rights Commission, and it's part of that. They've got an 8-step guide for preventing sexual harassment at work, and what I've done is I've put the QR code on the slide there so that you can easily access that guide, because it is quite a helpful document. So in terms of what constitutes or what will constitute all reasonable steps, that's going to depend on the specific circumstances of the employer, such as their size, the sector they're operating in, their working environment, the resources available, and other relevant facts. The duty to take all reasonable steps will include sexual harassment by third parties. Now, that's going to be a particularly onerous change for employers, especially those who are perhaps in the sort of retail or hospitality industries. So sexual harassment claims are likely to become harder to defend. And I would say that inadequately prepared employers are likely to face both the financial penalty of an uplift to the employee's compensation and also the potential investigation by the EHRC, resulting in possible enforcement action. So it is really important to be proactive around this. In terms of what SMEs can do now, I would suggest reviewing and updating your harassment policies, making sure that if you've got multiple policies, see if you can consolidate those into a clear, accessible guide, and one that staff will actually read and you can be confident that they are reading and taking on board. I'd recommend introducing short practical training. Keep it simple, but regularly applied. So for example, doing something annually, or making sure there's something as part of your onboarding process for new starters, and including real world examples that are relevant to your workplace can really help that training cut through to people. Sometimes it can be as simple as people understanding that actually banter is not always something that you can get away with. Look at risk assessing your environment and identifying any hotspots. Are there people who are working late shifts? As I mentioned, client-facing roles, events, particularly when there's alcohol involved, people who are lone working, and where you identify those hotspots, look to implement some light touch safeguards. Strengthening your reporting channels is really important to ensure that staff know exactly how to raise their concerns if they have any, and to ensure that you've got a simple process for documenting those. Strengthening your process for handling those complaints when they arise. So considering specific training for your line managers to be able to manage complaints of this nature, which are inevitably quite sensitive. And it's really crucial that your employees trust in that process. Otherwise, they're not going to engage in it. And make sure to keep evidence, because you are going to need to demonstrate the steps that you've taken if issues do arise. And as to the question of sort of why it matters, well, claims are going to be easier to bring, and they're going to be easier to win if employers cannot show that they've actively sought to prevent sexual harassment taking place in their workplace. So secondly, then, coming back around to that point about liability for third-party harassment, employers are going to be liable for the harassment of their employees by any third party, which means someone is harassing who is not the employer or not another employee. So this is going to include harassment from customers, clients, suppliers, other third parties, and importantly, it relates to harassment in relation to any protected characteristics. So any of the 9 protected characteristics are relevant here, not just the issue of sexual harassment. If an employer cannot show they took all reasonable steps to prevent the harassment, they will be considered to have permitted it and will therefore be liable for it. This isn't the first time we've had this kind of obligation. We did previously have liability for third-party harassment, but it was repealed in 2013. However, this new duty is actually more onerous because the old one, there was a requirement for the employee to have been harassed by a third party on at least 2 occasions, and for the employer to have had some knowledge of the harassment. And those are actions, those elements don't apply here. What that means is that an employee need only show that they have been harassed by a third party, and if the employer has failed to take all reasonable steps to prevent it, then liability will follow. For employers operating in sectors where their staff frequently come into contact with third parties, like I've mentioned, hospitality and retail, the duty is going to be particularly difficult to meet. The employer's lack of contract over those third parties was voiced as a concern by the House of Lords during the second reading of what was then the Employment Rights Bill. The government's response was that the expectations on employers in respect of preventing third-party harassment will be lower than expectations in terms of preventing harassment by their own employees, but it remains to be seen what that actually looks like. So in terms of what you should be looking to do now, add third-party harassment protections into your staff handbook and policies. There's going to be an explicit legal duty to do that soon. Train your staff on responding to problematic customer or third-party behaviour and who they need to escalate that to. Again, employee trust in those processes is going to be crucial. Implement an incident logging process. It doesn't need to be something complex, a simple spreadsheet, but so that there is somewhere that people can record when these issues are arising. And make sure that you're communicating a zero tolerance message externally where relevant to your third parties. So signage for hospitality and retail, recorded messages, client agreements for professional services, and just making sure that you do enforce that. Otherwise, it's all going to feel a bit toothless. So because it applies to all harassment and not just sexual harassment, the risk profile is much broader for SMEs. So it's something to be very mindful of. Linked into this, we've got changes that are coming down the track for non-disclosure agreements. What that's going to say is that if you are making provision in a non-disclosure agreement, it's going to be unenforceable where it is intended to prevent workers from making disclosures relating to discrimination and harassment. Now, although I'm talking about October 2026 changes, we don't actually know when this is coming in, but I'm talking about it here because it's relevant to the issue of harassment. So the government's aim is to prevent employers from misusing NDAs to silence workers about misconduct. The ultimate intention being that those employers will seek to change their business culture rather than seeking to silence people. The government apparently doesn't seek to reduce or ban the use of NDAs in appropriate circumstances, and it supports the right of businesses to use NDAs to protect sensitive business and commercial information, trade secrets, and other confidential data. When the new law is in force, it means that any provision that is included in an agreement between an employer and a worker, be that an employment contract or a settlement agreement, that's going to be void to the extent that it prevents the worker from making either an allegation of relevant harassment or discrimination, or information relevant to the employer's response to relevant harassment or discrimination, or the making of an allegation. So not only can a worker talk about the discrimination harassment, they can talk about how their employer handled that, and obviously reputationally that could be quite serious. And if you are looking to try and use an agreement to prevent that, you're not going to be able to do so. So what amounts to relevant harassment and discrimination for the purposes of these changes is as defined in the Equality Act. Victimization is not specifically mentioned in the new legislation, but it's likely that if there's victimization that falls within the bounds of what was the employer's response to an allegation or a disclosure, that's going to be covered by these new changes as well. And so anything trying to prevent the disclosure of that will be void also. And it's important to say that it's just those elements of the agreement that will be void. It's not that the whole agreement falls over, but they won't be enforceable. Next slide, please. So next on my list is the tightening of tipping rules and the duty to consult with your staff. So by way of a brief reminder, the current position is that since the introduction of the Employment Allocation of Tips Act 2023, employers have an obligation to ensure workers receive all tips, gratuities and service charges, and that they receive those in full. They need to be allocated in a fair and transparent way. So where you've got qualifying tips, gratuities and service charges, and those are paid at or attributable to an employer's place of business, and it's more than occasional or exceptional, an employer must have a written policy on how it's going to deal with those tips. So that's the current position. That's going to be strengthened come October 2026, in that SMEs must consult with their workers or representatives of their workers when creating or reviewing their tips policy. So either when making a tips policy for the first time, if an employer happens not to have done it yet, or when reviewing that policy. So in terms of what SMEs should be doing now, I think check your current tipping process to make sure that all qualifying tips are being passed to your workers and that your written policy is up to date. Plan a simple consultation process. This can be something quite brief, a meeting, a staff survey, sort of feedback over email, but there needs to be something. Prepare to share an anonymized summary of that consultation feedback, so that people can see what's been said, and that's going to become a legal requirement. And make sure to set up a reminder to review your tips policy every 3 years. That's going to be required under the Act. And as part of any review, to make sure that you're consulting with your workers on that. So in terms of why it matters, consultation with employees is mandatory. You need to make sure you've got a transparent system that is instilling trust in your staff and reducing disputes. And it's good for staff retention to make sure that you've got good paperwork in place. So the government is currently consulting on this. It's a consultation that's live until the 1st of April. So if you want to have your say on the new rules, now's your time for that. And it's called Make Work Pay, Strengthening the Law on Tipping. So next slide, please. A quick brief in relation to trade unions. So October 2026 brings about 2 practical changes in relation to trade unions that SMEs should be aware of. It's more of a heads up because a lot of SMEs are not having to work alongside trade unions very often. But firstly, there's going to be greater access to workplaces for unions in order to meet with workers and to recruit. So from October 2026, unions are going to gain a statutory right to access workplaces for recruitment, organising and collective bargaining. Importantly, this does not include access to organised industrial action, but it can mean either physical access where they're able to come in and talk to your staff, or it can mean digital access where they're able to make sure they can communicate with your staff. So what will happen in terms of this is a union will present an employer with an access request proposing the terms of the access they seek. The employer may then issue a response notice before the end of the response period. If the employer responds, the parties can then negotiate those terms. If there's no response or there's no agreement, it can be referred to the Central Arbitration Committee to make a determination. So in terms of what SMEs should consider doing now, I would suggest mapping out your workspace, identifying practical access points, so meeting rooms, break areas, digital channels, those kind of things. Create an internal process for handling union access requests so that you're not caught off guard, maybe having a single point of contact for dealing with those. Prepare for any negotiations on access agreements so that you're mindful that, if an agreement can't be reached, the CAC may look to impose one on you and may also issue financial penalties for non-compliance. There's going to be a detailed framework on those financial penalties, but that's yet to be consulted on. Review your policies and your manager guidance. Frontline managers need to understand that access cannot be unreasonably refused. So they need to be properly trained and equipped to deal with those kind of things. And as with so many things, make sure you're documenting your decisions. The statutory process is going to be quite prescriptive, and you need to be able to justify any refusal. So you need to be able to document that to show you're working out, so to speak. So it's a real culture shift and just something to be aware of. The second point on unions then is that there's going to be a duty to inform your workers of their right to join a union. So from October 2026, SMEs must explicitly inform all workers. It's not just SMEs, it's employers, but obviously we're talking to SMEs here. So explicitly inform all workers in the written particulars, so the employment contract, that they have the right to join a trade union. So important to look at reviewing your onboarding materials, your employment contracts, your offer packs, etc., to make sure that when that becomes mandatory, that's provided for. Look at preparing your templates now so you can easily switch over in October. Make sure to train your hiring managers so that they understand the duty and avoid anything that might be perceived as discouraging union membership, because that can cause some difficulties. Check your HRIS system to ensure that it can automatically issue updated particulars to new starters and that includes the new information. And as I've said, it is going to be mandatory, so there will be risks if you fail to comply with that. Next slide, please. So the final point from me then is just a quick one in relation to the extension of employment tribunal time limits. So from October 2026, the time limits for most tribunal claims are doubling from 3 months to 6 months. It's going to apply to all, pretty much all claims, including discrimination and unfair dismissal. Breach of contract doesn't look like that's going to apply to at the moment. So in terms of why that's relevant, obviously that gives people a lot more time in order to bring a complaint. You can't breathe a sigh of relief as an employer quite as early. You also need to factor into that the time that's taken in early ACAS conciliation. That can add on another sort of 6 weeks or so, and possibly longer in relation to those time limits. So tighten your internal investigations and your record keeping. Issues might resurface months later, so you really do need to have good documentation that you can rely on when memories have faded. Review your settlement strategies. The longer time limit means potential claims may hang over the business for twice as long, and that carries more than a financial risk. So, make sure that you're mindful of that. Update your HR policies to reflect the new timelines. Ensure that your managers understand employees will have longer to bring a claim. That might be relevant, for example, to something like a redundancy dismissal if you're then looking in the future to rehire. I've certainly had a claim where someone was made redundant and they saw their job being advertised, I think 4 months later, and they applied out of time to bring an unfair dismissal claim, but they wouldn't be out of time under this new regime. Look at using early resolution, so encouraging prompt dialogue, mediating to avoid disputes, and just in general, this does increase overall litigation exposure. So it is something to be mindful of. It can prolong workplace uncertainty and is something to therefore look to be trying to get on top of. So next slide, please. We're going to be running another quick poll now, just in relation to the need to inform workers of their right to join a trade union. I would be grateful for anyone who's willing to give a vote here. So what we're looking at is in terms of how you feel about this upcoming new duty. It may be something you weren't aware of before this morning, but whether or not you feel that how you are sort of informing is already clear enough. You can build it into your existing onboarding HR processes, whether it's manageable, but you will need to update your documents, whether you need to reflect on it or whether you're entirely unsure. So if anyone is willing to give a quick vote, that would be really helpful.
Just to remind everyone as well, it is anonymous. We can't see what you're voting on.
So at the moment, we're looking sort of pretty equal across the board, except no one is unsure. Feels clear enough is coming out ahead, so that's good. Yeah, I mean, it doesn't feel particularly onerous in terms of communicating. It's just something that you need to be alive to. We're all used to having a minimum number of things that we have to put into our written particulars, many of which need to be in a single document. So it's just part of sort of recalibrating your onboarding process really, and making sure that you've got provision in there for that. Perfect. So we've got 42% for feels clear enough, 42% for manageable, 14% for we'll need to give this more thought, and no one is voting unsure. So I think that's all sounds pretty positive, Laura.
Yes, it does. But I don't know if we know the detail of what it's going to look like yet at the moment.
No, not particularly. No, I don't imagine it's going to be overly complex.
No.
But we're a bit light on detail at the moment, as with so
Yes.
many things under the
Yes.
ERA.
Quite. I suspect it might be something that a template will be available, maybe on a government website, maybe via ACAS as well, possibly, with a bit of guidance on it. But the main thing is to remember to do it. So I think that's the main thing, isn't it, really?
Definitely. And I think, that whole point about remembering is why it's so important to get things into as part of your processes. And then it's one less thing that you have to remember because you've already provided for it. Brilliant. Well, thank you for listening to the October 2026 changes, everyone. I'm going to hand over to Laura now to talk to you about what's coming in 2027.
Thank you, Chris. Yeah, so this is the big flagship change that you might have heard about in the news a while back. There was a bit of what we call ping pong between the House of Commons and the House of Lords as to whether or not unfair dismissal rights should start from day one. And a compromise position was reached so that individuals will qualify for unfair dismissal. That's ordinary unfair dismissal rights from 6 months of employment. So that's a really big change, and one which could pose a significant risk to employers. And this change is going to take effect from January 2027. So unfair dismissal protection will kick in at 6 months from the start of employment, not as is currently 2 years. So it's a dramatically shortened period before which employees can bring this really important claim in employment law. So it effectively means that the point at which you need to be prepared to justify dismissal will arrive 18 months earlier. So you'll need to be identifying those risks, making sure that you're treating employees appropriately, and that includes addressing performance and conduct issues well in advance of that 6-month mark. So what kind of things should you be doing in readiness? Well, I think the probation periods are going to become far more important, and it's going to be crucial for businesses to reduce the length of those so that they end before the 6 months of employment. Let's say if you've got somebody that you realise doesn't quite meet your requirements. So you might want to introduce, for example, a new 5-month probationary period or even a 3-month probationary period. And probations are going to need to be structured so that employers are very clearly actively managing them, I would say, with review meetings. So if we're thinking ahead, it would be really useful to make sure that either you or your line managers, whoever is dealing with new recruits, feel that they're confident in raising concerns at an early stage with new starters, and make sure that they provide regular, very clear feedback and document any issues of concern there. So make sure that you've got performance check-ins and that you know exactly where everybody is on their timeline from when they start working for you, and that you've got good dismissal procedures in place should you need to use them. So really, I think it's making sure that you've got an infrastructure in place to deal with these types of things and make sure that they're managed properly. And if you've been used to using an informal dismissal procedure for individuals that haven't got particularly long lengths of employment, then I think that approach will need to change. And if you are an SME where you've got a high turnover, or you're in a seasonal sector such as hospitality or retail, then it might mean that you face an increased risk here, simply because you might have a higher turnover of staff, and then those individuals will be meeting that qualifying period fairly frequently, and you'll have to make sure that you're managing your new starters appropriately. Next slide, please. So another really important point in relation to unfair dismissal and changes ahead that will take place from the beginning of 2027. So I should have mentioned that these important changes in relation to unfair dismissal will be taking effect very early on in January 2027. So there'll be another important change whereby unfair dismissal compensation, which has been capped to date. So the current cap on a compensatory award for an unfair dismissal claim is £118,223, or 1 year's gross pay, whichever figure is the lower of those two. But from January next year, this cap will be abolished entirely, which means that for successful unfair dismissal claims, tribunals may be able to award an employee's losses without an upper limit. Again, that's a really major shift, and it could mean that there are higher financial consequences for employers. And the risk is particularly large where you might have a high earning individual, or where an individual has struggled to find new work, or it could be that they're going to have substantial losses because they're just not going to be able to find new work, maybe because of the way that they feel that they've been treated and the impact that that treatment has had on them. So that could mean that there's a much larger burden to pay in terms of unfair dismissal claims. So it's even more important to ensure that any dismissals are based on fair reasons and that you're using a fair process in order to prevent claims occurring or succeeding. So thinking ahead, even from the middle of this year, you may be taking on new employees who will be qualifying for those rights at the beginning of January 2027. And you'll need to make sure that you've used a fair process with them and potentially have fair reasons to dismiss them if they get close to that point and you realise that they're just not the person who fits into your organisation, which could be for one of many reasons. So you will just need to be prepared, and your managers, whoever's carrying out these processes, will need to ensure that it's all done fairly, above board, that there's fair reasons for the dismissal, and that a fair process is being used as well. So you might want to make sure that you've got checklists maybe to hand for things like probationary periods, managing new starters, and just generally thinking more carefully about what you're going to do in terms of recruitment, making sure that you're recruiting the right people from the outset, you're managing them, and that at every end of the employment life cycle, recruitment, probationary period, end of employment, it's done fairly. Next slide, please.
Laura,
So,
there is a question around this. I wonder if it might
okay.
be worth picking it up
Absolutely.
now. I think it was just a clarification. So up to January 2027, is the 2-year qualifying period still applicable? But I think what you just said is that if you have current employees in January 2027 that have been there 6 months, would that apply to them, or would it only apply to people who you take on from January 2027?
I think it would be important for the lead up to that point as well. So I think if you've got individuals who you dismiss just before January 2027, it wouldn't be a concern then. But if you've recruited people and then they tip into still being your employee when the new rights come into effect, I think that would be the concern there. Chris, I don't know if you agree with me on that, or you've got a different view.
No, I do agree. So yeah, up until January 2027, we're still working on the basis of 2-year qualifying period. But it is the fact that the new law is effectively going to have retrospective effect in rather than only applying to new employees. That mean that someone who was still quite a junior employee suddenly has unfair dismissal protection because they've been there 7 months. So it's important, even in this year, to think ahead in terms of what it's going to look like in January. If, for example, you were to issue someone with a written warning that was going to run beyond January, you wouldn't necessarily be able to act on that without thinking, because of the fact that they might have enhanced rights after January. But yeah, until sort of the end of December, or certainly within a week of someone having 2 years, it's still 2 years. So this is a change that will apply from January.
Yes. I would also say that the goalposts do move with the government. So it's possible that when we have more detail, that it becomes clearer, or it might change a little bit. And that's one of the challenges, I think, with the Employment Rights Act, that employers really just need to keep on top of the changes and maybe come along to updates like this, so that they're aware of exactly what's happening and what the rights and obligations are.
Exactly. I mean, we only got 6 months because that was the only way the government could get it past the House of Lords.
Yes.
So these things do change, as you say.
It was a big U-turn, wasn't it, at the time? Okay, so another really big change for employers who are affected by this is restrictions on the use of 0 hours contracts. So alongside the change with unfair dismissals, this was the other sort of big, I would say, headline change that the government has introduced, and they really, the Labour government really doesn't like 0 hours contracts, and it's trying to limit their use in a really kind of major way. So there's various duties, new duties, obligations, which are going to apply in relation to 0 hours contracts, which are going to make them maybe less attractive and more onerous for employers. And if you do use them, there's various processes and rights that will apply that you really need to be aware of. So the new duty or new duties are to ensure that people who work maybe in a less predictable way at the moment have guaranteed hours which could potentially become more predictable if an employee indeed wants that. So under the Act, employers must offer a guaranteed hours contract to reflect the hours that a worker actually works over a defined reference period. So the idea is that if you take on a 0 hours worker, that you will have to, at some point during their employment, and we've been told that the relevant reference period is likely to be 12 weeks, you will have to assess the hours that they're actually working, you know, what's happening, the reality on the ground, and offer them a contract which reflects that. It doesn't mean to say that the individual has to accept that contract, but every time the reference period comes up, periodically, you will have to carry out that exercise and offer them terms and conditions which reflect what they're actually working in practice. And that duty is going to apply to various categories of individuals who have yet to be defined in terms of the specifics and legislation, but it would be 0 hours workers, low hours workers who regularly exceed their minimum hours, and it will also include agency workers as well, with the end user, so that's the employer, usually responsible for making the guaranteed hours offer. There will be some exemptions and opt-outs, so that would include limited exemptions where a fixed term contract is appropriate, for example, where there's a genuine temporary work need or a one-off project, but the scope of what's counted as reasonable in those circumstances will need to be set out in regulations. And a duty can also be disapplied entirely by a collective agreement with a union, which means if you agree with the union that these obligations are going to be disapplied, then that will be a possibility which could apply in your particular circumstances in your workforce. And I think the idea there is to encourage employers to have unionised workforces, although my view is that unions will be keen to protect their workers, so I'm not sure why they would opt out of the 0 hours obligations and protections that we're told are going to apply. So once these obligations come into effect in 2027, and we're not entirely sure when they're going to come into effect during that year, if you don't make an offer of a contract with guaranteed hours, an individual can then bring an employment tribunal claim, but we don't quite know what the maximum award will be for that at the moment. So as I was outlining, really, I think the government is trying to make 0 hours contracts less and less attractive for employers and potentially difficult to manage, particularly if you've got quite a number of 0 hours workers. So you might want to think about, are there alternatives, alternative models in which you could operate your business that would still give you flexibility, or could you do without 0 hours workers? But I think the key now is to think, well, actually, what roles are likely to trigger guaranteed hours potentially in your workforce? do an audit of your use of 0 hours contracts and see, is it something that's going to affect you? Is it something that you're prepared to deal with going forward? Think about the operational and cost implications of potentially having to give guaranteed hours to workers that previously you've used flexibly, and just make sure that you are aware of the implications for your particular organisation, including where you use agency workers as well. And there's a part 2 to this as well on the next slide, please. So there's going to be another change as well. Currently, there's no statutory right to notice of shifts, but under the Employment Rights Act, workers are going to gain a right to reasonable notice of the time and day of the shift that they're expected to work, how many hours it will be, and also importantly, if there's going to be any change or cancellation to an existing shift. And if an employer gives short notice in terms of asking employees to come into work and then cancelling at short notice, there's going to be a duty on employers to make a proportionate payment each time a shift is changed or cancelled in that way. So a cancelled shift could include situations where you've got multiple workers who are offered the same shift and turn up to work, where a worker reasonably believes that they're needed, but where a shift is ultimately given to someone else. So if a worker turns up to work and reasonably believes that they were required to be there, they will have a right to claim compensation. And I know that's a situation that can occur, that employers can say, particularly in sort of casual worker environments, they want individuals to turn up, and maybe I think it could anecdotally occurs quite often at the junior end. You can have workers turning up maybe in hospitality, leisure sectors, and then actually not being needed to work a shift. So once this legislation comes into effect, they would have the right to claim compensation as a result of that. So key steps that employers affected by this could be considering now could be to review rota processes to make sure that you're moving forward to longer notice periods of shifts and reducing reliance on last minute scheduling as well. Identify where issues like this might occur, so where short notice changes might crop up. Have a look at your shift allocation practices. Are you routinely offering multiple workers shifts at once, where actually you genuinely only need fewer people than the number that you're offering them to? And make sure that you've got systems that are in place that ensure that workers aren't misled into thinking that they're required when maybe ultimately they might not be. So again, it's really just thinking ahead of the curve and making sure that you're organised and that you're in the best position once these new rights come into effect. Next slide, please. So there's going to be a reform whereby employees have stronger rights to flexible working. So that's really just building on existing rights which apply already from day one of employment. So the right to request to work flexibly might include asking to work from home, changing working hours, wanting to go part-time. And there are various statutory reasons that an employer can use to turn down a request that's made on those grounds at the moment. And those 8 statutory reasons will continue to apply. So they would include things like having to maintain a good service to your customers, clients, not being able to reorganize the work easily, not being able to recruit to ensure that you can meet client needs if you've got an individual, for example, who wants to go part-time. So those bits won't change, but the employer's obligations around justifying a refusal will increase significantly. So under the new Act, the test for refusing a flexible working request will become tighter. So the employer must state the specific statutory ground they're relying on, but also, this is the new bit, explain why that ground makes the refusal reasonable in those particular circumstances. The penalty for getting the statutory process wrong, so maybe not applying it within the relevant time periods, which is currently capped at £5,600, is not going to change. But the real teeth in these types of claims, where they're not handled properly, tends to be where there might be a discriminatory angle, and often that might be a sex discrimination point. So employers may turn down, this might be a typical claim, a woman who, let's say, is returning from maternity leave and wants to work on a part-time basis. And the sex discrimination angle is on the basis that currently more women tend to have greater caring, childcare responsibilities, and it's harder for them to meet an obligation by an employer to work on a full-time basis. So that angle of bringing a sex discrimination claim would continue under these new rights, but the added point for the employer to be able to justify, rather than simply saying, no, sorry, we can't manage it, is going to become very explicit under the new Employment Rights Act. So I would say it is another point for employers to consider. But if you're a reasonable employer and you're handling these requests, then I would say arguably you should be providing that type of information already to your employees and being able to justify why you're coming to that decision in the first place, and being able to evidence it clearly. If you've got a genuine business need why you cannot agree to a flexible working request, then you should be able to explain it and justify it in a fair and non-discriminatory way already. So really, I think it is, in terms of preparation, being aware of this new right and being prepared that you'll be able to, that you will have to document and explain your rationale for turning down potentially a flexible working request if you don't want to agree to it in the workplace even more clearly than previously. Next slide, please. So there's going to be change whereby pregnant and new mothers have greater protections in the workplace. So this applies to potential dismissals. So right now, enhanced protection applies to those individuals only in redundancy situations, but under the Act, the government could potentially introduce regulations that restrict dismissals generally during pregnancy, maternity leave, and a defined return to work period, except in specific limited circumstances. So we don't know what the final detail will be, but certainly the intention is that there's going to be protection, greater protection for those individuals, and there's expected to be greater protection in that way that will be extended also to individuals who are affected by adoption leave, shared parental leave, neonatal care leave, and bereaved partners' paternity leave as well. So it's really part of the government's policy aim of strengthening job security for all new parents and carers. And again, this is really just a heads up point to be aware of. And when we have more detail on it, you would be wise to update your policies and procedures and make sure that your managers are aware of these rights as well. Next slide, please. So this is another reform which is due to come into effect in 2027, and it creates a new statutory right to bereavement leave, including for early pregnancy loss. That's something that isn't currently covered in UK law. So under our current legislative framework, bereavement rights are very limited, and statutory parental bereavement leave only applies when a child dies under the age of 18 or is stillborn after 24 weeks. There's no dedicated right to bereavement leave for adult relatives or pregnancy loss before 24 weeks. Employees do have a right to unpaid time off for dependents in emergencies, but this is very narrow. It's not paid, and it's not designed for bereavement either, specifically. So the new right under the Act it will give the government power to introduce a day one right to at least 1 week of unpaid bereavement leave and leave for pregnancy loss before 24 weeks. So those are significant changes. Eligibility will still depend on the worker's relationship with the deceased, and we will know more detail about it in due course, but we know that it's due to take effect in 2027. So again, it's another one where you'll have to be aware of it and update your policies and procedures when we know more detail and it's coming into effect. And that's certainly something we can help you with as well, if you wish. Next slide, please. Now, I won't go into this in great detail because I've covered it off already, but it's a reminder that this new right obligations of employers to introduce gender equality in terms of the gender pay gap and supporting employees in relation to having menopause action plans in place. These obligations that apply to employers with over 250 employees are going to be voluntary from April 2026, so just around the corner, but mandatory from 2027. And I think it signals that a shift that the government is wanting employers to take in terms of reporting and supporting employees with proactive action in the workplace. So, as I mentioned previously, there is due to be further guidance for all employers on how to manage the menopause in the workplace, and it's something to be aware of and ensure that you're putting into effect. And that, I think, the obligations in relation to the menopause affect larger employers, but as I said previously, there's going to be an expectation across the board from employees, and also in terms of fairness, organisations like ACAS, and if you get taken to an employment tribunal in terms of a claim, that you have supported and behaved reasonably towards employees in those types of circumstances. So the gender pay gap and the menopause. Next slide, please. So restrictions on fire and rehire. So this point affects employers who at the moment may be thinking about making changes to contracts of employment, and there can be situations where employees don't want to agree to changes to their contracts of employment, and that might be potentially in relation to pay, hours, restrictive covenants might be examples, working hours. And if an employer wants to make those changes at the moment, if they have a reasonable business reason and inform and consult with those individuals, there is the option of potentially giving that individual notice and offering to re-engage them on new terms and conditions of employment once they've worked out their notice period. It's usually quite an extreme option, and not one that we would recommend unless there's appropriate circumstances for it. But it's something that the Labour government doesn't like at all as a practice. And there were cases I know that have been reported that you may remember in relation to P&O ferries, where employers have basically done the sums and decided it would be more favourable to them to dismiss and maybe rehire a new workforce. In terms of the cost to them, it would be something that they would be prepared to do and take the risk on. So again, the government is really not keen on those types of circumstances taking place. So they are putting a great deal of restrictions on fire and rehire, which should take effect from 2027, and making sure that if you dismiss an employee in order to make changes to certain protected contractual terms, including pay, working hours, pension, shift times, time off rights, and other contractual benefits, if you do that, an individual would have a right to bring a claim of automatic unfair dismissal. So there wouldn't be a way that you'd be able to easily justify it. There would be very limited circumstances in which an employer would still be able to do that, but that would be if you're an employer acting in response to serious financial difficulties affecting its ability to carry on as a business at all. And an employer would need to show that the steps that it took in terms of firing and rehiring or dismissing somebody and engaging on new terms and conditions of employment is not something that could have been reasonably avoided. And intentionally, that's intended to be a very high bar indeed. So if it's something that you're considering doing, without sounding cynical, in terms of changing employees' terms and conditions of employment, and you think that you've got a good business reason for doing it, it is something that would be worth considering now rather than further on down the track in 2027, when it's going to become a lot more difficult for employers to make those types of changes in that particular way. So I think I am handing you back to Chris now.
Yes, thank you, Laura. That was really interesting. Okay, so I'm going to talk to you about sort of practical compliance steps that you can take looking to get yourselves ready for the changes that are coming down the track. Now, on this first slide, I wanted to give you this QR code, which is to a brilliant article that Laura wrote actually in relation to sort of steps, 10 action points that you can take. It's aimed at HR, but employers in general can take to help get themselves ready for the changes that are coming. Now, we wanted these slides to be as useful to you as possible as a reference tool, which is why we've included these QR codes. And I understand the slides will be made available to you if they haven't already. And taking that point forward, we've tried to cram as much information on the slides from this point on as possible, again, so that they're available to you as a reference tool. It's not something that we would ordinarily like to do because we don't like slides to be too busy. Can I have the next slide, please? So in terms of workforce planning and looking to future-proof your business in the context of the information that we've discussed, you've probably identified from what Laura and I have been talking about this morning that the people-related risks that are or can be associated with the Employment Rights Act are going to increase. So we've got some higher financial penalties, we've got some increased litigation exposure, be that from decreased qualifying periods for unfair dismissal protection, 2 years down to 6 months, or an increase in the time limit for making a claim, 3 months up to 6 months. So if workplace decisions are being done poorly and or quite informally, aren't being properly documented, etc., that really is something that's going to be exposing employers to potentially a quite significant amount of risk. So the planning process is about sort of shifting from a reactive HR function to more of a proactive workforce planning approach. As SMEs, as many of you will be, you don't have endless pots of money available to you. But the systems and the models don't need to be complex. What they need is they need to be clear. They need to provide clarity. So thinking about who you employ, how you're resourcing your key functions, and where, in the light of the Employment Rights Act reforms that we've got coming, that might expose specific vulnerabilities particular to your business. These are all key considerations to be sort of sitting down and reflecting on. So it's more sort of like akin to identifying your pressure points and identifying them early on, so that you can help to plan rather than find yourself on the back foot having to firefight. So what does this mean in practical terms? I strongly suspect that the era of let's see how they get on might be coming to an end to a great degree. It's something that I've seen many times. I've had it multiple times where employers have come to me and said, look, this person's been slightly underperforming for a little while. We've had our concerns, but it's now kind of reached a head and we really need to do something about it. And they've been employed for more than 2 years. So even under the current regime, the situation is made far more difficult for that employer to manage. So those employers are going to sail through that 6-month mark, and so with that reduced leeway, people just need to be a bit more aware and proactive, and not seek to avoid difficult conversations, as I imagine that we're all guilty of from time to time. There's going to be a need for more emphasis on the quality of your recruitment and onboarding processes. So I think if a problem can be avoided, it's always better than trying to cure it. So that's something to pay some particular attention to. Being clear about the role definitions from day one, being absolutely straight in your mind as to who it is you're employing, what it is that you want them to do, and making sure that that's communicated to that individual as well, so that they know what is expected of them. Because when there is a divergence of those two things, that's where problems can really arise. Given the sort of smaller window of time that's going to be available to you as employers, you are going to need to more quickly identify underperformance and any other concerns, and take prompt action around that, as well as carefully documenting the what and the why of what's happened. Now, I sort of liken this to my maths exams when I was at school. Now, I've never been very good at maths, and my teacher used to sort of really labour the point with me of show you're working out. You might get some extra points if you show you're working out, even if you get the wrong answer. And this is really similar here. It's important to show you're working out and have the documents to rely on to demonstrate why it is you've done what you've done. So the particular risks are around inconsistent management decision making, reliance on informal practices, poor or non-existent record keeping, and rushed exits without evidence. Next slide, please. So the ERA is going to require clearer workforce structures. You might already rely on fairly informal staffing patterns, and Laura's alluded to this in her guidance. And SMEs often don't have the luxury of expansive teams of people. So an absence of just one person can materially affect operations. The way to tackle that is through predictable scheduling, cross-trained teams so that people can step into other people's roles, and clarity on who covers what. And these can all help to reduce the legal and operational risks that you might face. So going forward, SMEs are going to need to build day one and early employment rights into their hiring plans. They're going to need to strengthen their recruitment, as I've mentioned, and not just be thinking about speed. There may also be a need to rebalance towards core contracted hours, with any genuine short-term or seasonal roles being justified and that justification being recorded. As I've said, the qualifying period for unfair dismissal reducing to 6 months is a significant thing, as is the limit on unfair dismissal compensation being removed, as Laura discussed. So it's advisable for SMEs to invest more time in role design and selection, thinking about the person spec, who is it that's needed in terms of the individual and the personality, the job spec, what additional training there might be for those people who are responsible for managing that recruitment process. As I've said, aligning the job expectations nice and early so that everyone knows what the deal is, that's going to be really helpful, and ensuring probationary periods are really actively managed, as Laura has talked to. Next slide, please. Contracts and policies is perhaps an area where you can make your biggest impact nice and quickly. And those documents are probably going to become more about risk control than just sort of background documents. Your policies don't have to be long. They just need to be clear, current, and consistently applied. I quite often see clear policies that are not consistently applied, and that really does undermine them. So there is this link up between actually the action piece. Look at focusing on your high risk areas, so your probationary periods, your dismissals, your flexible working requests, your family leave, and making sure to get these right first time round. Keep your updates simple and practical so they're nice and easy for your managers and staff to follow. And if it's something that you need to bring in someone from the outside to deliver some training on, then there are plenty of people around who can do that, people like Laura and I, and other people in our industry. Key documents to update, it's not an exhaustive list. So your processes around probation, disciplinaries and dismissals, your family leave policies, bearing in mind what's becoming day one rights from April, your flexible working processes and paperwork in terms of making sure that you're properly and clearly documenting any reasons that exist around a refusal, adding your union rights information into your onboarding materials, and updating your equality measures in light of the gender pay, menopause action and harassment prevention aspects that we've discussed this morning. Next slide, please. So as I've sort of alluded to, the ERA really does represent a shift away from sort of that informal discretionary HR practice to a more evidence-based compliance landscape. You're going to be exposed if you cannot evidence your compliance, if you're relying on informal practices, or you're holding incomplete or inconsistent records. So stronger systems, there's sort of three key things: stronger systems, more detailed and accurate record keeping, and clear, consistent internal processes. I think that's kind of going to end up being the sort of trifecta. The creation of the Fair Work Agency is going to make record keeping more important again. And do remember that they will have the power to require any individual to provide information or documents by a specified date where they believe that person is able to provide information or documentation necessary for their enforcement purposes. So it may be that you have someone like the FWA asking for sight of your documentation, as well as things like data subject access requests, employment tribunal proceedings, and the like. I've made the point already, but it's worth making again. Simple systems really are fine. Spreadsheets and basic HRIS tools, they do work as long as they're accurate and they're kept up to date. So just think to yourself, if someone asked me about this tomorrow, could I evidence why I've done it today? And that should hopefully see you not too far wrong. Next slide, please. Appreciate I'm zooming through these, but I'm mindful of the time. And as I've said, we've made sure to put the information on the slides as much as possible. So create a simple ERA timeline and communication plan for yourself. Do keep it simple. Break it into manageable steps with realistic deadlines. Make sure you're communicating those changes. Keep an eye on the government website, ACAS website, and adjust your plan as the information evolves. We will continue to post articles on our social media platforms and on our website to try and keep employers nice and up to date. But clear communication, it reduces confusion and hopefully builds confidence. And that simple timeline should help you to stay on track. So the final poll of the talk, we're a few minutes before the end now, is just in relation to gauging from you, if we may, what area of the ERA feels like it might be the biggest challenge for you, whether we're thinking, predictable hours and the changes around 0-hour shifts, the strengthening of probation and early performance management, updating your contracts and policies, manager training, or the systems and record keeping. What are people sort of feeling in the room in terms of what might be the biggest challenge for them? Updating contracts and policies is 100% at the moment.
Well, we can help with that.
Yes, absolutely. And I think what's really the positive note to take away from that is that that's possibly one of the easiest things to get right. So yeah, as Laura said, we can definitely help with that and get you in a good place for being able to issue those when they are needed. So yeah, 80% updating contracts and policies and 20% systems and record keeping. So yeah, all things that we can help with and help to guide people through. Okay, so the last slide, if we can switch to that, please, Kirsty, is just making that point that I've just made is we're here to help. Our details are available. We're doing lots of this work. That's why we're actively training on it. So if there is anything that anyone needs, then by all means do reach out to us. And then the last thing to say is really just thank you for being here this morning and sticking with us over what was a long seminar. There's a lot of information to fit in, and it's difficult to even fit it into 90 minutes with splitting it over 2 webinars. So really do appreciate your input and your engagement. if anyone's got any questions, Laura and I are happy to field those. Obviously, we've had some as the talk has been going on, which has been fantastic. But if anyone's got any final burning questions, it's not now or forever hold your peace, because we're still around. But it might be a great opportunity, and it might be that other people are thinking the same thing.
Just lots of appreciation, and I've put all the links that we've talked about in the Q&A as well, just in case people miss those QR codes or don't. You will get the recording, so you can go back. But I just thought that might be useful. And you expertly finished on 11:30 there, Chris. Well done. That's really good. Yeah, no questions, but thank you so much. This webinar has been brilliant, and thank you so much for your time. So I think with no further questions coming through, we will leave it there. But I just wanted to say a huge thank you to Chris and Laura. We've had some fantastic feedback for both of these webinars, and we will be sharing the recording of these webinars on our website, so people can go back and re-look at them. We know this is, obviously a major change for employers, and so therefore want to make sure that people have access to all that information. And as they say, they're sharing some fantastic information on their social media as well. And I've shared Laura's article in the chat, so people can go back and have a look at those 10 HR points. But other than that, thank you so much for your time. Thank you for joining us today, and all the best. And please do get in touch if you have any questions around this or any other sort of business development, business growth areas. Please do feel free to get in touch with either hit us at the Growth Hub, and obviously Chris and Laura and their excellent team are on hand as well. Brilliant. Thank you so much for your time, and we'll leave it there. Have a great day.
Thanks. Bye. Bye. Bye.